fentanyl and norfentanyl on 810. Negative on everything else. I don't know if there's but she enrolled in the next day. So, have you had any positive tests since then?
No, sir.
Okay. All right. Well, then the court will find that the defendant does meet the criteria and is enrolled in the TRIVIEW, which I'm familiar with which is a certified treatment program. So, Ms. Dugan, I've been presented then with this plea of guilty form and as well as an entry that will grant your entry into the intervention and legal conviction program. Now, under the law, Ms. Dugan, normally when a person pleads guilty to a charge, the court finds that person guilty, and then there's a sentence. The sentence could be prison term, in this case of 6 to 12 months. It could be a fine of up to $2,500. There could be a license suspension of between 6 months and 5 years, or there could be community control or probation for a period of up to 5 years. But if that happens, that means the person is a convicted felon and has a felony record. Now, there's a provision under the law, and I'm sure you've gone over this with your attorney and probably talked to your counsel about it, but I have to explain it to you on the record so it's clear that you understand it. There's a provision under the law that a person who pleads guilty, if it's to a qualifying offense and it's a finding that a person's drug problem or mental health issue contributed to the commission of the offense, then instead of being sentenced after they plead guilty, the court can put them into what's called intervention and legal conviction. The way that works is it's kind of like probation or community control, except the conditions aren't nearly or fairly strict. But there's a requirement that you be in a treatment program, which is why we need this proof that we didn't have this last year. And if you are in that program, and I can put you in that program for up to 5 years, I normally do a review as well, 2 years. And you have to comply with that treatment program. It's also necessary that you not use any illegal substances or drink alcohol for a period of at least 1 year in your treatment program. That's by statute. And the reason I don't do alcohol is because that's another form of self-medicating, which is what a lot of people that have substance use disorder are doing, is they're self-medicating. So that's just another form. So the law says if you do either of those things within 1 year, then you can be terminated. But if you go through your treatment program successfully and you comply with all of the conditions in the in the intervention and legal conviction program, and pay your court costs, then once the court is notified of that, even though you pled guilty, the case will be dismissed. Because what happens if you plead guilty through this agreement, I'll accept your guilty plea, it'll be filed in a case, but instead of finding you guilty, I will put on what's called a stay or order of abeyance, which means that it stops and it's inactive. It's still open, but it's inactive while we await a report from the probation department about your progress in the program. And so, if you complete the program, the case gets dismissed, even though you pled guilty, you're never found guilty, and I actually will have a hearing after that, and 30 days after that, and seal the record as well, when nothing else happens that causes any problem for you. And then there will be removed the record, and you'll never be a convicted felon. So that's the big advantage to you. Now, in the event that you do use illegal substances, illegally, or if you drink, or if you fail to comply with your treatment program by going to meetings and so forth, or if you don't comply with the supervision requirements of the probation department, then they will have to file a written notice of that with the court. And if that happens, then you will have an attorney, you will have a hearing, you'll be aware of the charges beforehand, because they have to give you a copy. And if the outcome of that hearing is that you fail to comply, and at that time the court would terminate you from the program, and then you'd be found guilty, and then there would be a sentence. Now, again, you do have a right to have a hearing on that matter. Now, if that happens, it doesn't mean that you would necessarily go to prison, because you would still be eligible for regular community control, which is also 5 years. But the conditions of that are there are many more conditions, and they're more restrictive and defining, so to speak. And so, or you could go to prison, depending on what the circumstances were. If you committed another crime or something, might make it likely, but it doesn't mean it will happen. But you could go to prison for 6 to 12 months. You could also be fined $2,500, and you can have your license for 6 months to 5 years. If you go to prison, then the law provides as part of the sentence that once you complete the term that you were sentenced to by the judge, the adult parole authority can keep you on post-release control for a period of up to 3 years under the conditions they set. And if they determine that you failed to comply, then they can send you back to prison, even though you served the entire prison term set by the judge for an additional period up to half of your prison term for one or more violations. But if your violation is a new felony, then in addition to whatever sentence the judge in the new case proposed upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year or whatever time left on that period of post-release control, whichever is greater. That occurs, that has to be served consecutively sentence in the case. You understand all of that?
Yes.
Okay. Now, the agreement here, I didn't ask you this, but on page 3, there are signature lines right at the very top of the page. There's a sentence, one sentence that says, "I enter this plea voluntarily." Right below that, there's a signature line, and it looks like that is Evelyn Dugan's signature up there at the top. You recall signing this agreement?
Yes.
When did you sign it?
Last week.
Last week?
Yeah.
Okay. All right. And so Mr. Kirk went over with you before you signed it, explained it all to you?
Yes, sir.
And you understood that it's an agreement to plead guilty, which means there won't be a trial. In the
Yes.
next case, it's death, and then the disposition, which in this case will be, I always tell people, yes, I'm in the program, so that means that's what will happen.
Yes.
Okay? You understand that?
Yes.
Okay. Are you entering into the agreement to plead guilty voluntarily?
Am I free will?
Yes, exactly.
I mean, this is your choice, not somebody making you do it.
Yeah, right. Notice, yeah.
So nobody, what the court's asking is nobody's pressuring you.
Oh, no, nobody's pressuring me. No.
And what I would say is this, nobody does this because they want to, but you're faced with a charge and evidence and things going, you have to make decisions. And we all have to make decisions sometimes based on bad circumstances that we don't have the ability to change. So you take the best route for yourself. And so that's basically what I'm asking you is this, are you doing this voluntarily based on your decision as to what is in your best interest and the understanding of the circumstances, as opposed to doing it because you're being forced to or
No,
threatened?
I'm doing it on my own free will.
Okay.
It's what's best.
All right. Thank you. All right. Now the agreement states on page 1 that you are going to plead guilty to the charge of breaking and entering under 2911.13a, fifth degree felony. And it further states that you understand that the maximum prison term for that, if one was imposed, would be 12 months, the minimum would be 6. There's also a fine available of $2,500. I said there was a license suspension. I'm sorry, I was thinking it was a drug case. There is no license suspension in this case because this would be the drugs was the problem, but not the offense in your case. Most of the ones I get are drug offenses, so I just let habit guide you there, so that's not a mistake. There is no license suspension.
Okay.
Okay. All right. And you're not facing any felony charges anywhere else, right?
No.
Okay. And you're not on probation, community control, post-release control, or parole for a felony in any jurisdiction.
No.
The pretrial here doesn't count because it's, any other cases, you don't have any other cases.
No.
Okay, now, the charge reads that on or about March 8, 2021, in Highland County, Ohio, you did by force, stealth, or deception, trespass in a building at 6513 Sleepy Hollow Parkway and an unoccupied structure. Purpose to commit therein a theft offense, defined in ORC section 2913.01 or a felony. The violation of section 2911.13a, defined revised code. So that's the charge of the breaking and entering, the fifth degree felony that we talked about. Penalty being 6 to 12 months in prison and a fine of $2,500, the maximum, or community control, or in this case, an intervention. Now, you understand the charge and possible penalties.
Yes.
And do you understand what it is the state has accused you of having done, when, where, how, and that you did?
Yes.
Now, have you discussed the charge, the evidence in the case, legal issues possible in the case, and possible defenses you try to raise at a trial, and possible outcomes of a trial with your attorney?
Yeah. Yes,
Are you satisfied with this advice and confidence in this matter?
yes, I am.
All right. Now, you're taking mentally assisted treatment right now?
Yes.
Getting, what is it, Suboxone or?
Yeah, I have an appointment today too for the mental health.
Okay.
Well, after I leave here, I gotta get
Well,
straight.
what I'm at, have you had any injections yet or pills for Suboxone or subcutaneous?
Yeah, I brought my Suboxone.
Okay.
I
All right,
just
so-
mentioned
Other than, well, let me ask it this way. The reason what I'm asking is, are there any, are you under the influence of any types of drugs or alcohol at this time?
that. No,
And you are taking prescriptions, but are any of the prescriptions you're taking interfering with your ability to understand what is going on here today, what I'm saying, or
no, they're not.
or communicating your own thoughts?
No, it's not.
Alright. If there's anything you don't understand, which we've already had a couple of questions, just tell me and I'll try to explain.
Okay,
Okay? Or ask your attorney, either one.
okay.
Now, other than being promised to be put into the diversion program, or into the intervention in lieu of conviction program, has anyone promised you anything to get you to plead guilty here today?
No,
Do you hold any license or certification from any state, board, or agency for any kind of an occupation or profession, like an STNA or nurse's aide or anything like that?
STNA, I've had it since 1999.
Okay. All right, well, the reason I bring that up is this. In the event that you're convicted, this doesn't count because it's not a conviction. There won't be, and this is what happened. But if you are ever convicted under the law, then the clerk of courts is required to send a copy of the conviction entry to a licensing board for them to be aware of it, and not to tell them to do something. It's just we're required to tell them so that if they think they should do something, they will do it. So just so you know that, now, it's not going to happen on this here today.
Okay, that's what I was asking, like,
Yeah,
the
because
whole
you're
show
not
for my
convicted.
job.
Yeah,
Okay,
you're not convicted. But if anybody wants to look at it, even though you pled guilty, you're not convicted, but it would mean they would be aware there's a charge pending. So if you get into anything, if not ask anything about it, you might want to get a hold of, have your attorney give you a copy of this entry that I want to sign, if we go through with this. And then that way it shows that you're not convicted
okay,
and that you're in the program. But this is just for the worst case scenario if if you were to be found not to comply and then be sentenced and found guilty, then that won't happen until that. If you complete the program, it'll never happen.
okay,
If you don't complete the program, if you found guilty and sentenced, that time then it would happen.
okay,
Okay? All right, now, you have certain rights you must understand because, again, the way this works is this is your last chance to actually defend the charge and go to trial and try to be found not guilty. But you have to plead guilty to go into this program. And so because of that, you have to understand the rights that you're giving up by pleading guilty. Now, the first right you have is you're not giving this one up. Under the law, you have the right to have counsel. I appointed Mr. Kirk to represent you. But I didn't appoint him simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So again, if you don't want to do this, if you want to defend the charge, go to trial, he'll continue to do that and represent you until the case is concluded. Do you understand that?
yes,
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens from this county that are summoned for jury duty on your trial date. After they were selected, the evidence would be presented, they'd be instructed on the law, and then they would decide whether or not the state proved your guilt or proved beyond every reasonable doubt. Now, and that would have to be done by a unanimous verdict. All 12 the jurors have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial. Then in that case, you have what's called a bench trial, meaning that the judge would be the one to hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond a reasonable doubt. You understand that?
yes,
Right, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
yes,
Now, under the Constitution, Ms. Dugan, you have the right to use the power of the court, compel witnesses to come to court to testify for you, just like the state. So what that means is that any witnesses that you have, you don't think will come voluntarily, at your request, the court issues a court order for those opinion. And that forces those people to come to court to be able to testify if they want to, even though they don't want to be here or be involved, which is the same way the state's witnesses are forced to come to court. Do you understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself at any time, including the trial. No one can ever make a testimony. Prosecutor can't, judge can't. You make that decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even have to comment about it, except in one situation, and that is if there's a jury trial and you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes.
Right, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of that charge. So what that means is that the burden of proof isn't on you to prove that you're not guilty. The burden is upon the state to prove that you are. In fact, at trial, you don't have to put on any evidence at all. You can, but you're not required to, whether you do or not. The burden remains on the state to prove your guilt, but prove beyond reasonable doubt on every essential element of that charge, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Now, originally, you pled not guilty. Not guilty plea denied the allegations in the indictment, denied you committed the crime, and it exercised or invoked all of the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite. Not guilty to plea. The guilty plea admits the allegations in the indictment, count one, admits that they're true that you committed that offense. That plea waives or gives up the rights I just described, except your right to have an attorney. You will always have a right to have an attorney no matter what your plea is. But with that exception, your plea of guilty waives gives up your right to have a jury court trial, waives gives up your right to confront witnesses against you and cross-examine your attorney, waives gives up the right to use the power of the court, compel witnesses to be here to testify for you, just like the state, waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what finds you guilty, waives gives up your presumption of innocence, because if you say you're guilty, then the state's not required to prove you guilty. It also subjects you to being sentenced immediately by the court, although I'm not going to do that, legal. But it also waives gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if in the future I should sentence you to an maximum sentence or under other limited circumstances, it could be an appeal filed. It would have to be filed within 30 days of your sentencing entry being filed. Now, do you understand all of that?
Yes.
And you are a U.S. citizen?
Yes.
Right, now, Ms. Dugan, do you have any questions about the charge or the possible penalty?
No.
You understand?
Yes.
Have any questions about the version or the intervention program, or what's going to be required?
No, sir.
You understand it consists of both reporting, complying with certain conditions in the probation department, as
Yes.
well as doing what your treatment program requires, including remaining free of any non-prescription drugs.
Yes, sir.
If you do have lawfully prescribed drugs like Suboxone, you have to provide your prescription to the probation department when you get it. You understand that?
Yes.
All right. Any questions about the constitutional rights of the plan?
No,
You
sir.
understand?
Yes, I understand.
Any questions about the applicability of what the consequences of that be entered here today?
No, sir.
You understand?
Yes, I understand.
Is there anything you'd like to speak with Mr. Kirk about before we go into it?
No, sir.
Okay. You have any questions about anything that I've explained to you today?
No.
Okay. And is it your decision to withdraw your non-guilty plea, plead guilty to the charge, in accordance with this agreement just went over?
Excuse me?
Is your decision that you're going to plead guilty based on this agreement?
Yes.
Just signed? Okay.
Sir.
Before we go to that point, Mr. King, is there any restitution going to be included in that?
Our office spoke to the victim back on July 20th. He was instructed to provide restitution to our office.
Did not?
Failed to do so, so no restitution.
And inform the victim of this disposition?
Yes, sir.
All right. Then, Ms. Dugan answered the charge in count one, which alleges that on or about March 8, 2021 in Highland County, Ohio, you did by force, stealth, or deception trespass in a building on 6513 Sleepy Hollow Parkway, an unoccupied structure with purpose to commit therein a theft offense defined in ORC section 291301 or a felony. The violation section 2911.13A of the revised code. In charge of breaking and entering, a fifth-degree felony, carrying a possible penalty between 6 to 12 months in prison, fine of $2,500. How do you think?
Guilty. Guilty.
All right, thanks. You can be seated. All right, the court finds on this day open court defendants violates all constitutional rights, may willing, tells, and voluntary waiver saying so for Rule 11, please accept it or not. And is found guilty of the offense. I'm sorry, she is not found guilty of the offense. Please accept it or reply. But there will be no finding of guilty made because the defendant is eligible, qualified for placement in intervention to the probation program. She's been in effective in Brightview certified treatment program for drug dependence, substance use disorder is a factor of criminal activity, and likely that treatment will substantially reduce the likelihood of any future criminal activity. She is not a repeated dangerous offender and is otherwise eligible under law for this disposition. So, court orders that the guilty plea, although be filed, be held in advance. Criminal proceedings are stayed, and the defendant is placed under community control supervision of this program at the county probation department for a period of 2 years. It is also ordered to successfully complete an intervention plan through Brightview, including the requirement of the law that she abstain from using drugs or alcohol other than the prescription drugs lawfully prescribed for a period of 1 year. She complies to all the terms and conditions that are included in the program that the board has previously approved. We give a copy of those. If you complete the plan successfully, obey all the conditions, then upon notice of that from the probation department, state, court will dismiss the charge against you. You're also ordered to pay court costs as part of those conditions. Now, in the event that it's alleged that you have failed to complete and comply with any of the conditions imposed, either probation department conditions or treatment plan conditions, then you'll receive written notice of that from the probation department. There will be a hearing held on that. You will be represented by an attorney, and they prove that you have failed to comply, and at that time, the court will find you guilty. You will be subject to being sentenced to a term of 12 months in prison and a fine of $2,500. And if that should happen, as I said, then it could be post-release control down the road, but we don't need to talk about that today because you are being found guilty and you're not being sentenced. All right, so this will complete your case. All the pretrial supervision conditions are lifted. You're no longer under house arrest. You're now under the new conditions. As soon as you leave the room, go down to the probation department and report to them and let them know that you were just put on intervention due to conviction. And so they'll make an appointment for you. I don't have time today. They don't make an appointment for you to come back, go over all the new conditions because, again, they're different. They're a little bit more strict than this, other than there's no house arrest now. Go over those so you have complete understanding.
Okay.
All right, and then further counsel.
There you go.
All right, that's